And Judge, I think they're outside the hall.
Counsel, on their appearances, please.
May it please the court, the state appears by Jason Lopez, Assistant County Attorney.
Defendant appears person by through his attorney, Stephen Agency.
Counsel, we're on for non-evidentiary preliminary examination today.
Judge, we would waive preliminary examination, and I believe we have a resolution of this case for the court's consideration.
All right.
Judge, it's my understanding that Mr. Royal will be pleading to count 2, the operating vehicle with no interlock device. Counts 1 and 3 will be dismissed. In sentencing, excuse me, we'll recommend a 9-month underlying sentence. That'd be suspended and be placed on probation for 12 months. Additionally, we will be asking that as a condition of his probation, he undergo a drug and alcohol evaluation and follow its recommendations. And Judge, there is no fine associated with that particular traffic statute, and we will not be asking for one as well.
That's your understanding of the agreement.
Yes, Judge.
Mr. Royal, is this what you want to do today?
Yes, ma'am.
Have you had enough time to discuss this with Mr. Jensen?
Yes, ma'am.
Do you understand, sir, that even though you enter a plea of guilty to this charge and you all have an agreement, I am not required to follow it?
Yes, ma'am.
All right. And you understand that in pleading guilty today, you're giving up your right to have this misdemeanor tried to a jury or to a judge?
Yes, ma'am.
That's what you want to do?
Yes, ma'am.
All right. To count 2, failing to have an interlock device when required to do so, how do you plead?
Guilty.
Mr. Orpeza?
Yes, Your Honor. Had this matter proceeded to trial, the state would have presented evidence that on the first day of November 2015 in Miami County, Kansas, the defendant, Anthony Royal, came into contact with the Palo Police Department. After coming in contact with him, they observed that, 1, he was operating the vehicle, and 2, that the vehicle he was operating did not have an interlock restriction, or did not have an interlock device installed on the car, and his license was restricted to having an interlock device whenever he operated a motor vehicle.
Any objections to that finding?
Yes, Judge.
Court will find the defendant guilty of 1 count of failure to install and using a vehicle without an interlock device. Remaining counts will be dismissed pursuant to plea negotiations. Mr. Jensen will let the defendant waive his right of allocution if the court follows the agreement.
Yes, Judge.
Mr. Royal, I'm going to sentence you to 270 days in the Miami County Jail. I'll suspend that, place you on probation for a period of 12 months to be supervised by court services. You're to obtain an alcohol and drug evaluation and follow all recommendations. You will be required to sign releases so that your court services officers can contact your treatment providers. You're going to be responsible for court costs, a fingerprint fee, a supervision fee, and you have 14 days to appeal my ruling. Mr. Royal, I'm going to assume that you will not doubt me when I tell you I will jail you if you violate any of these orders. Do you believe me?
Yes, ma'am.
Very good. All right. They're going to get you all signed up for probation. If you're struggling for any reason, be truthful with them and they'll help you get back on track, okay?
Yes, ma'am.
All right. Mr. Jensen, did I already something out?
Judge, I wanted to ask, because of the problems we had before, you had asked him to put an ankle monitoring on. I do have a report from the SCRAM system that was placed on him from March 18th to March 30th, and they indicate there was no alcohol consumption events or no tampering events reported. With this now being done, is it okay to remove that?
Yep, that was a condition of this bond, and he's released from that, so he's free to take that off. Thank you, counsel.
Do you want a copy of this report?
I'm good. I believe it. Thank you. 16 CR 32, State of Kansas versus Robert Butters.
May it please the court, Your Honor, the state appears by Elizabeth Sweeney, Miami County Attorney.
Thank you, Court, Your Honor. Mr. Butters appears in person and testified before his attorney, Bill Stein.
Status, Mr. Stein?
Judge, at this time, I've had an opportunity to speak with Ms. Sweeney Reader. What we were asking for is a preliminary hearing. If we could set that 6 to 8 weeks out, Judge. I know Ms. Sweeney Reader has some obligations with regards to some other cases. There is a exhaustive amount of discovery that I think both sides need to evaluate and go through. So if you're willing to go out that far.
Sure. How much time do I need to set aside?
I honestly think a half to a whole day, if there's that much evidence and that many witnesses that are potentially going to have to testify, Your Honor.
Friday, May 13th available?
Judge, I do have a preliminary hearing scheduled in Johnson County on that day that I need to be on.
May 27th?
I'm available that day, Your Honor.
State's available.
Friday, May 27th. I'm going to set aside the whole day, counsel. If you don't need it, that's fine. Otherwise, you'll have a whole day.
Thank you, Judge. I do have one other request. Judge, I know the court has indicated that you would like a written motion with regards to bond in the event that you make a motion on bond. There was also the other issue with regards to publicity and media attention. I wanted to make sure that I had all of my facts together before I made any motion like that. What I am requesting is a 15-minute motions hearing sometime 30 days out where we might be able to address those two issues in preparation and anticipation of hearing, Judge.
Counsel, April 21st or May 5th after the morning?
Judge, April 21st would work just fine for me. I'm wide open. Stays
Oh,
available.
this May readers are available.
Okay. May 5th at what time, I'm sorry? Or May 5th, I apologize. At what time?
In the morning, I could do 9:30, 9:45, 10, 10:15.
Judge, if we could do 9:30 that day, that'd be great.
Ms. Sweeney?
That's fine, Your Honor.
I'm going to say motion on bond and media issue.
Thank you, Judge.
We'll see you back here then. May 5th, 9:30.
And Judge, one of the issues that you had ordered with regards to bond did call for my client to be evaluated should he make bond. My client has requested that you order that a psych evaluation be conducted while he's in custody if you're willing to do so. I don't know if you, I don't know if that issue's come up before, but if it's a possibility to have someone from Miami County Mental Health.
Why would I need to order it? I mean, if you want to, if you want him evaluated, you can do that. Are you
Well, in order
concerned about
for-
him being at the jail or?
No, it's with regard to the state's position on public safety issues. I think the court's level of concern in the bond that you set, you contemplated that a psychological evaluation would be necessary for him to comply with any treatment recommendations should he be released. What we're asking is that while he's incarcerated, in light of the fact that the state and court have requested a $250,000 bond in the nature of that the public safety, we're asking that he be evaluated while in custody.
Okay, you can do that, but you're asking me for an order, and I'm kind of not tracking with that.
Well, we're asking that the state, since it's their request that he be evaluated, that the state be responsible for the evaluation. In other words, in order to have him evaluated by a private evaluator, he'd either need to be released or we'd have to be having to retain somebody to come down and evaluate him. I don't think that's logistically very feasible, and we're just asking that the court order that he be assessed while incarcerated.
Ms. Sweeney-Reader?
Your Honor, first of all, it's my understanding with mental health, at least it's been this way in the past, if the court orders an evaluation, they don't allow any sliding scale. It's completely up to the party to handle that evaluation. Insurance doesn't cover the evaluation. Anything that's court ordered, I believe, at the mental health center with regards to a psychological evaluation or a mental health evaluation. So I don't know that the party, that the defendant really wants the court to order that, because there would be no leeway, I don't believe, with the state, with the community mental health centers as far as sliding scales, payments, anything along those lines.
Well, I don't think he cares because he wants you to pay for it, if I heard him right.
Correct, and I think that the state's position presupposes that somebody be released and then evaluated as a conditional bond, and that's not where we're at in this case, Your Honor.
Well, and we're not requesting for one right now. We're requesting one that if he is released, then he gets one, and that's not the state's obligation to pay for, Your Honor. If he's going to use it as part of his defense motion or as part of his defense in general, that's something that's upon the defendant to pay for. He's hired counsel, and therefore the state should not be responsible for any of those fees.
Tell me again the purpose of the evaluation?
Well, Judge, the court took the position, and I would suggest that that was in significant part, being presumptuous, Judge, in significant part in light of the probable cause affidavit that was submitted to you at the time that the state sought to file the case. I think the allegations suggest that my client is mentally unstable, either a danger to himself or to other people. So the court has ordered that should he post bond, he be evaluated and be subject to any treatment or therapy recommendations. What we're asking, Judge, is that in light of that being a concern for the state and for the court, while my client's incarcerated and financially unable to post bond, and by the way, he did not personally retain my services, does not have the financial means as he lost his job over this issue. We're asking that the court order that he be assessed while in custody at the jail. He's also been farmed out to Lyon County, so he's not even being housed here locally. So that's why we're asking that that evaluation be ordered by the court. My hope would be that he be held here locally in order for that evaluation to be conducted, but that's my position.
Okay, I'm going to decline to grant that. I think the purpose of the evaluation is so that the defense can use that to alleviate any concerns I might have about his public safety. But that, I don't have those concerns while he is incarcerated. I have those concerns if he is not incarcerated, which is why it's a condition on the protective order. So I'm going to decline that request, and I'm going to see you all back here May 5th. I don't have promotional filing.
We have
10 days, 2 weeks would be great.
Okay, thank you.
As long as I have time to see it before the hearing.
Understood, I'll take care of that.
Thank you.